I had a case years ago. It's probably been 10 years ago now, but people still talk about this. It was a Wednesday morning, and I finished my docket, and the assignment commissioner called and said, "Oh, Judge, we've got an indecent exposure case. You know, it's an appeal from the district court. Can you take it?" I said, "Well, sure, send it up." So it wasn't a jury trial, it was a court trial. The fellow was charged with indecent exposure. And it turns out there was some condominium association where there had been a dispute. Someone ran against a member of the association board, knocked him off in the election. And these positions don't pay anything. It really is kind of a little fiefdom, I think, that people like to have. Well, these people, there was bad blood between them, and the gentleman that was defeated came out of his apartment unit one morning, and the woman who defeated him came out of hers, and they had an exchange of, I guess what you'd say, a frank exchange of views. And he turned around and dropped trowel, and he mooned her. The police were called, and I'm not sure they knew what to charge him with, so they charged him with the common law crime of indecent exposure. There were other things they could have charged him with, but it was an odd, common law charge. So he'd been convicted in the district court and appealed it, came up in front of me, and I remembered from law school that indecent exposure, by definition from the common law, involved a display of the genitalia, not of the buttocks. So I took a recess, went back and did some research. There was a Washington, D.C. case directly on point. Well, D.C. adheres to Maryland common law because D.C. was carved out of Maryland. So this case in D.C. interpreted Maryland common law. And it was a woman that was protesting in front of the Supreme Court with a placard on the front of her. She was bare naked, but she had this placard on the front of her. She was arrested, charged with indecent exposure, and in D.C. on appeal ultimately said, no, that's not indecent exposure because there's no display of the genitalia. So I came back and I told this guy, I said, it's a good thing you weren't charged with being a jerk because then you'd be convicted. But I said, as it stands, technically this is not indecent exposure, so I'm going to find you not guilty. I didn't think anything else about it. The next morning I'm drinking my coffee, reading the Washington Post, and on the front page of the Post, judge declares mooning legal in Maryland, which was not exactly what happened, but sometimes the press, for whatever reason, there's a fascination with either sex or bathroom business and courts. And the next day, they kept up with this story. The next day it was cheeky ruling, and I was getting calls from all over the country. The ACLU wanted to know, did I have a written opinion on this? They saw it as a symbolic free speech argument. I said, no, this is a district court appeal. There's no written opinion. This was, I was getting calls from, John, The Daily Show. They wanted to pay my way up to New York to go on The Daily Show to talk about this. And I thought, that's not really going to be good for the court. It's not something that would be a dignified thing for me to be involved in. So I respectfully declined. But it's funny. I feel like of all the cases I ever dealt with, the important cases and precedents and rulings, probably the one that'll be on my gravestone is mooning judge,